So we are in record mode. And as our attendees continue to join, I thought what I would do is I have an opening poll. So let me go ahead and put that up. So here's the poll. So anyone who's joining us, go ahead and vote. On the question is, what workforce planning strategy have you used so far? And to the extent you can, if you can answer our poll, we'll take a look at it. We're getting lots of people voting in. Those attendees who are just joining us, we've got a poll for you to take just to welcome you to our webinar. We're expecting a full webinar. We have room up to 100, and we're getting we should be almost full. So welcome new attendees. We're going to wait till we have wait just another minute or so to get all of the attendees, give everyone a chance to sign up and actually go through the login process. I think everyone's getting used to the Zoom process. My process has always been that if I can't figure it out, I'll just keep clicking buttons until I get in. IT wasn't very happy when they found out about it, but Susan said, okay. All right, so for those attendees who are just joining, if you haven't already done so, please take our poll. This is our opening poll. We're just waiting for all of our attendees to sign in, and then we'll get started. So I am going to show any attendees, if you haven't done the poll, I'm about to end it in about 5 seconds. All right, there we go. I'm going to end the poll. And before I share the results, let me just follow up with everybody and give everybody some introductions. Welcome everybody. I'm glad you could join us for this timely topic of workforce planning strategies. From the response, it's clear that this is a hot topic for everybody. Let me do some introductions. So to start off with, let me introduce the chair of our group, Beth Radigan.
Hello, everybody.
And then in our Brattleboro office is Tim Copeland.
Actually my dining room, but hello everybody.
and David Harlow.
Morning.
And Andrea Wright.
Hello.
Then in our Lebanon office, now also working from home, is Beth, as you've already been introduced, and Amy Braun.
Hi.
And then in our Burlington office, but now also working from home, is April Tuck.
Hi, everybody.
She's our labor relations consultant, and Ben Travers.
Morning.
And also want to thank Monique Trono, who's not on, but she has been an amazing support in putting all of this together, and I know you've all gotten lots of emails from her. So some preliminary matters. Our session today is organized again into 4 sections. Each section will be about 10 minutes of presentation, and then we'll have some time for questions and answers. And when you're putting in questions, please use the Q&A feature, not the chat feature. We'll be monitoring the Q&A feature closely. So if you have a question, please make sure you use the Q&A feature. Also want to remind everyone that this session is being recorded. Today is June 2nd. The law is changing in this area very quickly, so please make sure to check in for updates if you're viewing this in a recording. Also a reminder that what we're talking about today is general legal guidance. We're not providing specific legal advice for any specific situation. Those are all unique situations depending on your specific circumstances. And so, if we have those situations, obviously we'd be happy to talk to you about it, but that's not going to be part of the webinar. At the end of the webinar, you'll get a copy of the PowerPoint, so don't worry about taking notes. We'll send you a copy of the PowerPoint. And you'll also get information from Monique on CLE credits, HRCI credits, and SHRM credits. So let me share the results of our poll. Can everybody see the results there? So it looks like we've got a mix of everything. We had, some people have done furloughs of reduced hours. Some people have done furloughs of just completely not working. One person did furloughs essentially reducing pay. We've had one person do layoffs, one person do a reduction in force. And then there's, of course, the combination option. And I think some of you are waiting for your PPP expiration and haven't made any changes yet. And then probably the largest group is you haven't made any changes yet, but my guess is you are looking at making changes down the road potentially. All right, so I'm going to close out of the poll. And now I'm going to start sharing my screen. And Beth Radigan will lead us off in our first presentation. So go ahead, Beth, take it away.
Good morning again, everyone. Thank you for joining us today. We appreciate you joining us for the seminar. Generally, I want to start off with the concepts of furlough, layoff, and other sorts of job changes. This question came up a lot in the beginning, so it's something to sort of have a general understanding about as we talk about these issues. There is no specific legal definition of a furlough versus a layoff, and it can be confusing because people use these terms interchangeably. But generally, there are differences that you can associate with each of these terms. A furlough is considered generally a temporary leave of absence, but it's mandatory by the employer because of various business reasons. It's a situation where the employee is expected to return to work. And a notable difference about it is that employees may continue benefits while they're on a furlough, and usually it's not, well, it depends, can depend on the situation and your policy, but usually that people can continue benefits because you've communicated that it's a temporary situation. And people may receive unemployment benefits if under the current situation, people are receiving employment benefits. Under prior situations, for instance, the Vermont Department of Labor initially took the position that furloughs, the beginning of the COVID situation, that furloughs of up to 10 weeks would be considered okay for purposes of obtaining benefits. But again, this is really a state-by-state situation. There are some states that have legal definitions and requirements specifically for furloughs, California being one of them. But there's no legal definition distinguishing furlough necessarily. But we have come to recognize it as a temporary situation. A layoff, on the other hand, is a permanent separation due to lack of work. And it doesn't matter that you've called it one or the other, but there are implications for benefits and other things that can distinguish these two terms. So a layoff will typically trigger COBRA. Now, there are some policies as a result of this COVID situation where insurance companies have come back and say, okay, we're going to let you elect to continue and not have COBRA be triggered by this, but you'll have to check with your policy. It's really driven by the policy. But generally, a layoff is considered a permanent separation. It would trigger COBRA. You have to send all your regular COBRA notices out. Some employers will continue to offer to pay for a limited period of time. It depends on the circumstances, and a lot of employers are doing different things here, depending on the financial circumstances. And unemployment also, benefits may be available, like they may be available under furlough. It is likely they're going to be available most definitely under a layoff situation. But you're going to hear more about unemployment by David later in this presentation. And you're also going to hear more about a number of the other issues that are triggered by furlough and layoff, such as WARN Act issues. Tim and Andrea are going to talk about the WARN Act in a little bit. So this is really just an overview of furlough versus layoff. One thing that is important in a furlough, if you're furloughing exempt employees, you have to pay the full week's pay if that exempt employee performed any work during the week. So if you decide to furlough on a Wednesday and your regular pay days work week is through Saturday, then you've got to pay the full week for that exempt employee. Non-exempt employees, of course, you can stop pay the last day they work. Next slide. So the thing to remember about layoffs, and there will be, I think that the unique circumstance we're in right now is that there are some folks, as we saw on the poll, who've done some furloughs already. There are some folks that may be contemplating them as the PPE loans are ending, coming soon, and we don't know what the status is of whether those may be extended at some point by government legislation. But right now, you're looking at possibly having people on furlough who you are not able to bring back. So if you're going to lay off someone who's on furlough, it's a lot of the exact same considerations that you would go through if you were laying off someone who is an active employee. So the analysis is often the same. So it's really important from the employer's perspective to think through the criteria that you will be using to select those people that you may be laying off. So it may be that it's a department by department criteria, or it's, you're finding that like the sales team is just, you're just not needing a sales team, although that's probably a bad example because you probably really need a sales team during this time, but maybe a production team or some other category of employee. That could be a criteria. Or criteria could be, within a department, we're going to look at our certain manufacturing group, production workers, because our orders have slowed down. But then within that group, we're going to look at seniority, for instance. Or we're going to look at performance-based decisions. And this is a reality because a lot of employers will, in a layoff situation, want to say, okay, I'm going to lay off the people that aren't as productive or aren't as helpful to my business. But if you're going to do it for performance-based reasons, I think it's really important that you have some documentation of that and how you applied that. So rather than just going to a supervisor, for instance, and saying, okay, tell me, who can we lay off? You want to be able to document, okay, we based it on the, people that were on some sort of performance improvement plan, or people who received less than stellar reviews during the last annual review, or people who've had an ongoing problem that we've discussed with them. So factors are just the same kind of factors you would always consider. Even if someone's already on furlough, you should go through that process if you're thinking of permanently letting that person go. You have to be cognizant of disparate impact. So even though you don't intend to discriminate against any one group, you should be looking at things like, are we laying off everybody who's over 60? And that can obviously be a problem from the age discrimination standpoint. So you do need to kind of look at the data and look at who you're making decisions about. Or is it all women and not men that we're laying off? Or is there an over representation of women in the number of people that we're laying off? So just as you think about the layoff, those are the factors that you should be evaluating. And you document how you went ahead and apply those criteria. So the issues that come up, of course, are COBRA. Whether or not it's triggered, you should check with your insurance policy to figure out if the furlough or the layoff. The layoff is most definitely a triggering event. Whether a furlough is maybe dependent on the policy. PTO payout is another one. Generally with the furlough, because it's temporary, you don't have to do a PTO payout. You can if you want. You don't have to. And you could actually ask people to use their PTO also in a furlough, but generally we advise have it be voluntary if people are going out. But certainly for a layoff that's permanent, obviously the PTO payout has to happen if you have a policy that under your regular handbook policies that would require you to pay out. You should check employment contracts. Now, for instance, some healthcare providers have employment contracts that you would not be able to furlough or lay off without still incurring the obligation to pay under the contract. So if you have any individuals that fall under an employment contract or even an offer letter that says we will pay you a severance, for instance. You should check any employment contracts that you might have. And of course, if you're a unionized environment and you have a collective bargaining agreement, there are going to be limitations under that agreement potentially of who and how you go about any kind of layoff. I think a notice of termination is important in some kind of realm, in some way to demonstrate the reason. And obviously we know we're in a COVID time. And so people can assume, well, that's what it has to do with, but I think it's really important to at least have a document for each person that you're going to lay off saying this is the notice of the termination. And we'll have more on the WARN Act coming up shortly. And then whether or not you go and offer a severance agreement, again, that can be a decision that you make. You are not required to provide a severance agreement unless you are contractually required to do so, but ordinarily you are not. Those are considerations that Ben will go into in greater detail. And the other thing for you to think about is whether there's, in lieu of a layoff, a mandatory layoff, maybe there's a voluntary leave a program that you can consider. But you do have to be careful about voluntary leave because it has to be truly voluntary. So one thing that employers like to do is, well, we'll offer it to these people because those are the people we'd like to have leave, but oftentimes the people that you'd like to have leave choose not to leave, and then the people that you don't want to leave do choose to leave. So remember, you have to live with whatever the person determines. One alternative is job restructuring. I know some of you have already tried this as shown by the poll, but obviously you can reduce hours and reduce compensation and save on your budgets that way. You can offer flex time or shifts to perhaps not work a full work week or work different times available. A compressed work week, so maybe 4 days or 3 days where they're 10-hour or 12-hour days. Telecommuting and telemedicine, both are obviously the remote work situation has become ubiquitous throughout this time, and it's used even in the medical field, so that's an option. And some employers are deciding to continue that even after the return to work orders are in place. There will be a number of people that will continue to engage in remote work very effectively. Then, of course, job sharing is another option. It's key when you're any of these options to sort of figure out who is best suited and to keep best suited to these sort of arrangements and to keep in constant contact with people about how this is working, because it doesn't work for every employee and you need to be able to be in a position to manage that. But these are all alternative ways to get around the problem of how do we keep our workforce working.
All right, Beth, thank you very much. Good overall summary. Amy has been monitoring questions. Amy, is there a question that we can throw out there?
Sure. One question is regarding paying a full week of pay for a furloughed exempt employee. Is that only for the week you furlough them, or if they do any work, such as participate in a phone call or meeting during the furlough? For example, some small profits may have only 1 to 2 employees that they may need to stay in touch with.
A great question, because this has come up. If an exempt employee is performing any work, you do have to pay them for the full week's pay. So if they're participating in occasional meetings or phone calls on a regular basis here and there, that's a problem. Now, what some employers are doing is changing the status. They're changing them to non-exempt for the period of time and say, we want you to work 10 hours a week and we're going to pay you 10 hours a week. So you can do that. That's perfectly fine for a temporary change of that person's status.
All right, great. Amy, do you have another question?
Yeah, can a furloughed employee volunteer to work or help, even if they are asking, not the employer?
Another great question. Volunteering for work that person would normally be paid for is generally forbidden by the Fair Labor Standards Act. If someone is doing the work that they had been, and certainly there are many good-hearted employees that will volunteer to do that, you cannot legally allow that person to volunteer to do that same work.
Okay, great. Amy and Beth, thank you very much. Just a reminder to all of our attendees is that if you have a question, please use the Q&A. We're going to move over now to Tim and Andrea, who are going to talk to us about the WARN Act. But if you have questions, please use the Q&A feature. All right, let me share my screen here, and we'll be back. So Tim and Andrea, take it away.
Okay, thank you, John, and good late morning, everybody. It's very nice to be with you. It's the next best thing to being with you all in person, which we look forward to doing again soon. It's an interesting time to be looking at the WARN Act issues. We're about roughly 3 months or so into this extraordinary period that we're in. And I am going to be very interested to see what takes place in September and October of this year, and I'll explain why that's the critical time frame in a second here. But now is a good time to be thinking about some of these things if your workplaces are large enough that the statute applies to you. The federal statute, it's called the WARN Act, it's been around for about 35 years, applies to employers of 100 or more employees. The basic requirement is 60 days notice of a plant closing or a mass layoff. It requires notice to be sent to affected employees or their union if they're unionized employees, and to the state dislocated worker unit and the chief elected official of the unit of local government. There is an exception to the 60-day notice requirement for unforeseeable business circumstances. But it's important for employers to keep in mind that that does not outright excuse giving any notice. It simply means that an employer that gave less than 60 days notice of a plant closing or a mass layoff can avoid liability if there were unforeseeable business circumstances that would have made giving notice at the 60-day mark impossible. I would expect that there is going to be litigation over that issue here. This statute, unlike the state statutes that we're going to talk about in a minute, is enforced only by the courts, which means that federal courts that where lawsuits are brought claiming violations of the WARN Act are the mechanism by which this statute is enforced. That makes it a little more difficult to predict because there could be dozens of different federal courts that are construing language not entirely the same. You see a lot of quotes around terms in there, and it's important to understand that each of those terms has its own meaning in the statute and the regulations. A mass layoff is a reduction in force which is not the result of a plant closing, and second, results in an employment loss at a single site of employment during any 30-day period for at least 33% of the active employees, excluding part-time employees, and at least 50 employees. In other words, the numbers would need to comprise at least 30% and at least 50 employees, except in a very large workplace where 500 or more employees are affected. The WARN Act would apply without regard to whether those 500 comprised 1/3 of the workforce. Here's the part where I think there's going to be some interesting litigation, probably in September or beginning in September or October. When we get after what label employers put on their actions, whether it be a furlough or a layoff. The Act has its own definition of employment loss, which is an employment termination other than a discharge for cause, a voluntary departure, or retirement, a layoff exceeding 6 months, or a reduction in hours of work of individual employees of more than 50% during each month of any 6-month period. So a short-term layoff, meaning a layoff of less than 6 months, is not an employment loss triggering the WARN Act coverage. Now, when this emergency fell on us in roughly March of this year, certainly many employers expected and hoped that the need to conduct layoffs or furloughs was going to be short term, and they would be recalling people much sooner than the 6-month mark. And if that turns out to be the case for an employer, then they will not have any reason to be concerned about potential Warren Act coverage. The problem begins, what if this crisis and the economic downturn that resulted from it drags on past the 6-month mark? Were that to happen, those layoffs would be considered employment losses dating back to when they occurred. So my general suggestion for employers is if they conducted layoffs or significant hours reductions in such numbers as would constitute a mass layoff at the time, even if they expected the layoffs to be short term, if it's starting to look like people are not going to be recalled prior to that 6-month mark, the employers should consider whether they ought to give notice now. And in fact, the regulations directly address this issue and state that an employer who has previously announced and carried out a short-term layoff, meaning a layoff of 6 months or less, which is being extended beyond 6 months due to business circumstances, including unforeseeable changes in price or cost, not reasonably foreseeable at the time of the initial layoff, is required to give notice when it becomes reasonably foreseeable that the extension is required. So 3 months in, an employer that then foresees that its layoffs are going to extend beyond 6 months is well advised to err on the side of caution and give notice. Okay, next slide, please, John. Okay, Vermont, like many states, has its own mass layoff and plant closing. These are colloquially referred to as mini Warren Acts. Vermont's applies to employers of 50 or more employees. Where it applies, it would require 45 days notice to the state and 30 days notice to the employees, their union, and local chief elected official or administrative officer in the event of a business closing or a mass layoff. There you see the definition of mass layoff under the state statute. The good news for employers in Vermont, unlike the Warren Act, which is enforced through litigation when one or more employees believes that the statute has been violated, the state statute is enforced by the Vermont Department of Labor, and it announced fairly early on in this crisis that it was not going to enforce the act with respect to what would otherwise be considered business closings or mass layoffs that were caused by the pandemic and the resulting stay-at-home orders. So helpful clarity from the state on the Vermont statute. I'm now going to turn things over to Andrea, who will discuss the New Hampshire statute.
Thank you, Tim. Good morning, everyone. In addition to Tim's remarks related to the Federal Warren Act and the Vermont Mini Warren, New Hampshire also has a Mini Warren Act. And New Hampshire has specifically provided that it applies to employers that have 100 or more full-time employees. The notice requirement is to be given 60 days before an event of unemployment loss, which constitutes a plant closing or a mass layoff. It is to be given to 4 different types of recipients. The notice is to be given to the employees that are going to be affected. It also needs to be given to the employee's representative in case in the scenario where the employees are represented by a union, for example. In addition, it needs to be given to the Commissioner of the Department of Labor and to the New Hampshire Attorney General of the Department of Justice. And finally, a notice also needs to be provided to the local chief elected official of the municipality where the employment loss had occurred. Similarly to the federal law, a mass layoff is a reduction in force that results in unemployment loss during any 30-day period. But in this scenario, in the state of New Hampshire, there is a different quantity of employees to need to be considered for a mass layoff. 250 full-time employees or 25 full-time employees if those 25 full-time employees are 1/3 or 33% of the totality of the full-time employees. Similarly to the federal law as well, there are exceptions that the law includes related to if it was reasonably foreseeable at the time that the notice was required. And one of those situations particularly could be applicable for the COVID-19 pandemic. It's important to mention that differently than the Vermont Department of Labor, the New Hampshire Department of Labor at the beginning of the pandemic did not make a pronunciation related to what they believe, if they believe that the enforcement of the notice provisions were going to be applicable in the state of New Hampshire, or if there were any type of relaxation requirements for the notice. Later, in late April, I believe, the Department of Labor acknowledged that there are some exceptions that could be applicable to the COVID-19 pandemic and that would relax the notice requirement. Specifically, it published in their website that this pandemic is clearly an emergent and exceptional event that allows for the relaxation of the notification requirement. So in addition to the New Hampshire Mini-Warn Act, there is another law that New Hampshire has enacted that is a New Hampshire fact-finding for mass layoffs law, which is applicable to any employer that has New Hampshire, an employee in the state of New Hampshire. But the requirement of notice is not to be given to the employees. Rather than the filing of the mass layoff notice is to be given to the New Hampshire Department Employment Security Office, which is an NHES. And it is supposed to be given to this agency if the employer believes to or expects to lay off or lays off 25 or more individuals in the same calendar week for at least 7 days. And this layoff is due to a vacation holiday shutdown or a company closure. There is a specific and different timing for the notice to be given to the New Hampshire Department of Employment Security, depending on the reason why this notice has to be provided. If it is supposed to be provided because of a vacation or holiday shutdown, the report is required to be given within 7 days, business days after the calendar week of the layoff, when the layoff occurs. But if it is because of a company closure, the report needs to be provided within 3 business days. Again, this is not necessarily a specific WARN Act, but there are also notice requirements that are mandatory for an employer in New Hampshire in a case of layoff. That's what I have. John, you can see if we have any comments or questions now.
Okay, great. Tim and Andrea, thank you very much. April has been monitoring questions. April, any questions for Tim or Andrea?
Absolutely. We have 2. The first one, Tim and Andrea, has to do with the 100 employees. And those 100 employees, is that based on FTE or the number of bodies?
Yeah, good question. The answer is a little tricky under the federal statute. For purposes of determining who is an employer that is covered at all by the statute, employers defined as a business enterprise that one or more, including part-time employees who in the aggregate work at least 4,000 hours per week, exclusive of hours of overtime. I guess the idea there would be to include within the coverage of the statute an employer that had 200 employees that worked 20 hours a week. So they would in the aggregate reach the 4,000 hours a week threshold.
Okay, thank you. And then the second one is, does the Vermont WARN Act apply to a seasonal business that is only open for a few months each year?
Good question, and I'm going to have to look the answer up.
All right, thank you. That's all we have here.
Okay, Tim, Andrea, April, thank you very much. Just as a reminder to all of our attendees, if you have a question, please log it into the Q&A, and we are monitoring that closely. So our next section is going to relate to severance considerations, and Ben Travers is going to lead that discussion. So Ben, go ahead and take it away. So Ben, if you're talking, I think you're on mute.
Yes, sorry,
Yeah,
needed to
there we
unmute
go.
myself there. Thank you. So over the last 10 or 11 weeks or so, I'm frequently asked, as I suspect many of you are, are you busy? Are you staying busy? And my response has been that yes, we've been busy, but for a lot of the worst reasons possible, which is that many of you are having to make very tough decisions now with respect to these workforce planning strategies, which is why we're focusing this session on some of those issues. And what I want to focus on here briefly are voluntary or involuntary severance plans. As a shameless plug here, if you are considering either a voluntary or an involuntary severance plan, to cut to the chase, we recommend that you check in with legal counsel, because as we're about to briefly review here, there's potentially a number of legal pitfalls in going through these plans. But at first glance, right, in considering whether to do a voluntary or involuntary plan, a voluntary plan may be the preferable option. It's giving employees the choice to sort of choose their own destiny, so to speak. But you need to think about what considerations need to be made. As Beth mentioned in her presentation, first of all, if you're doing a voluntary plan, it must be truly voluntary. It must be truly the employee's choice in signing up for it. So what do you need to do in order to make these plans truly voluntary? Well, first of all, you need to offer the plan to everybody in a select group. Now, the select group could be, for example, everyone with a certain number of years of service for the company, everyone within a certain department. But once you've selected that group, the plan needs to be made available to everyone in that group. And you also need to be careful about targeting through a group that's too limited. So, for example, if you've set the group at everyone with more than 20 years of service, and you only have 2 people in your organization with more than 20 years of service, and they happen to be some of your older employees, that is an area where you could run into some issues. And then beyond that, once you've selected your group, in order for the plan to be truly voluntary, you have to accept everyone who volunteers for the plan. So you can envision circumstances where you have employees volunteering for the plan from a certain shift that you have, where suddenly you no longer have employees on that shift. Or you could be getting the wrong volunteers, so to speak. As Beth mentioned, you could have some of your top performers signing up for the plans and not the folks who perhaps you might prefer for performance-related reasons or what have you. Again, whereas there are those pitfalls for voluntary plans, we recommend, of course, that you talk to legal counsel, because if that's what you want to do, there are ways to figure out how to do a voluntary plan and to do it well. But whether it's involuntary or voluntary, there's other legal requirements to consider as well. We would always advise you, if you're doing a severance package, to secure a general release, a release of any and all claims that an employee may have against the organization. And if you're going to do that, there's certain statutory legal requirements about developing a severance plan. This is a document that's going to outline a formula for benefits, explaining to employees what benefits they'll receive. So for example, if you've been for the company for a certain number of years, that translate into this amount in severance plan, severance amount. The severance plan document's also going to explain employees' eligibility criteria. And then there's a law out there called the Older Worker Benefits Protection Act, which defines an older worker as anyone over the age of 40, which many people over the age of 40 take exception to, but that's nonetheless the law. And that law requires that in order to secure a good release, that you have to provide employees the titles and ages of all individuals who are eligible and not eligible for your severance plan from whatever group you've selected. You also have to provide employees a 45-day period within which to consider the release, and they get a 7-day revocation period after signing it within to revoke it. If you've done individual releases for employees before, perhaps you're familiar with the 21-day consideration period and 7-day revocation period. This is the same concept. It's just that if you're offering this in the context of a severance plan to 2 or more employees, those periods are extended. And again, this is doubling up on something that Beth said, but it's another important point to reiterate here, which is that while that Older Workers Benefits Protection Act is focused on age, and while this document showing eligible, non-eligible employees is focused on age, it also provides you a good opportunity to consider, is your plan inadvertently having an adverse impact on folks in other protected categories? Is it weighted one way or another with respect to gender, or with respect to race, or other backgrounds? So it's a good idea to expand that adverse impact analysis beyond just age. A couple other pointers here, which is that if you're dealing with a bargaining unit and wanting to do a voluntary or involuntary severance plan with them, the terms and conditions of that plan are going to need to be bargained for. And then as a good segue here into my colleague David Harlow's presentation on unemployment, is keep in mind that any severance package is going to be credited against unemployment eligibility. So as David will speak to, many of you are aware of these federal benefits that are available at least through July, where employees can earn an additional $600 a week. If you're trying to develop a severance plan that is sort of helping employees to best land on their feet, these are some things you may want to take into consideration. Is where is the severance money in terms of where it lines up against what the individual would earn if they were on unemployment. I suppose one other thing that I should mention on the unemployment front is that, this may end up being something that David covers as well, is that at the moment, if employers are having to lay people off or let people go because of COVID-19 related reasons, they are relieved of charges to their experience ratings for a certain period of time. But there are requirements that in order for that relief to stay in place, that employers need to make a good faith effort to rehire individuals who have been laid off as a result of COVID-19. So it's another thing that you may want to consider, is if you think that you're laying folks off and will be relieved of charges because you've heard of changes to the unemployment law that David will speak about momentarily, keep in mind that if you're not having those people come back on again down the line, that there may be impacts with respect to your experience rating.
All right, Ben, thank you very much. Amy has been monitoring questions. Any questions on the severance topic?
Yeah, we have one that's a little more general than just severance. Let's see. It's if you temporarily restructure a full-time exempt position to 10 hours a week for about 5 to 6 months, can the employee still apply for and receive unemployment compensation? I don't know if David knows.
Yeah, that might be a good segue into David starting off his, if you're good with that, David, or I could take it.
Or
Go
I,
ahead, Ben.
or I can also sort of goes into some of this job restructuring possibilities. So it will depend on what that person is being paid. Generally, a reduction in pay and a reduction in hours would may possibly allow that person to receive unemployment benefits, but it's a formulaic decision and generally depends on how much that person is being paid.
Okay, Amy, any other questions?
That is it.
Okay, well, that's a perfect segue then into David's presentation related to unemployment. So I'm going to share my screen here, and David, why don't you take it away?
Hi, everybody. As you've learned from almost every one of the prior presenters, unemployment is a legal issue that intersects with these sorts of decisions to either reduce the workforce or put people out on furlough. One of the primary takeaways from furloughs that have happened over the past several weeks is that employees are going to be eligible for unemployment benefits for the most part when out on an unpaid furlough. And that was a hot topic when furlough decisions were initially being made. And that continues to be the case. In the midst of that, there were some fairly substantial changes to the unemployment statutes in Vermont via executive order in New Hampshire, and then with the passage of the CARES Act, changes at the federal level. So in connection with these very difficult employment considerations, the government at the state and federal level have made changes to relax unemployment standards and make it more available to employees affected by the crisis. In Vermont, the changes to unemployment eligibility were indeed substantial, and basically these changes flipped on its head the general principle in unemployment law, which is that you're not going to be eligible for unemployment if you voluntarily ended the employment relationship as the employee. So in other words, if you quit, you can't get unemployment. That principle was changed fairly substantially for employees who felt compelled to leave their employment for certain reasons related to COVID-19. One of the most highly visible of those is if an employee believes there's a, quote, unreasonable risk of being infected with COVID-19 at work, they may be able to quit and still be eligible for unemployment. Unreasonable risk, as defined by the Vermont Department of Labor anyway, means that the employer really has to be violating some announced, published workplace safety rule, either through OSHA or the Vermont equivalent. And so it may be difficult for an employee just to claim unemployment or quit and claim for unemployment based on a generalized fear about getting COVID-19 that isn't substantiated with some legitimate example of an employer violating workplace safety standards. Now, of course, any employment claim is subject to a fairly wishy-washy system of proof, and employees may be able to argue that they witnessed coworkers not social distancing, that people were not wearing masks at all times, things like that that may be hard to prove or disprove. And so given the flexible nature of unemployment compensation generally, we suspect that many employees may be able to quit and take advantage of those flexible standards. Perhaps even more concerning would be an employer who's faced with a situation where an employee quits and claims that they have to care for a family member who left employment due to an unreasonable risk of being infected with COVID-19 at work. And that's the second to last bullet point on this slide. Under the changes to the Vermont unemployment statute, if an employee quits to take care of a husband or wife or other close family member who left their employment due to what they perceived as an unreasonable risk of being infected, then they could conceivably be eligible for unemployment. And I don't know how, as an employer of the person quitting, you're able to prove or disprove what happened at their family member's place of work. So all of that said, the changes here to the Vermont system of unemployment are fairly substantial. And with these new changes, we can expect that employees will be more capable of getting unemployment, particularly for these COVID-19 related reasons. Now, the Vermont Department of Labor has responded to legitimate concerns of employers and explained that as employers bring people back to work and makes offer of reemployment, those employees who refuse suitable and safe work would be disqualified for benefits. That's a response to concerns that a lot of employers had. And it's also important for employers to bear in mind because, as Ben mentioned, employers may be relieved of charges if they rehire or offer to rehire employees displaced by COVID-19 related issues within a reasonable amount of time. And so making those offers is important, even if some of them are refused. In New Hampshire, very similar changes were made via an executive order and provided unemployment eligibility to employees who left employment for qualifying reasons, which are outlined on that slide. In addition to these state changes, it's important to look at the federal changes as well. And John, if you go to the next slide, with the CARES Act, there were additional forgiveness and employee benefits for people that were affected by COVID-19. The most publicized of those is an additional $600 per week for employees who are out of work as a result of COVID-19 related unemployment. That expires at the end of July. There's been an attempt in the House to extend that beyond July, but so far that's proven unsuccessful. The $600 from the CARES Act, in addition to state benefits, in some cases creates the appearance of a disincentive for employees to return to work once being called back if they're not making enough money at their employer to basically make more from unemployment than they would if they went back to work. And so that particular provision has gained a lot of publicity, but it's expiring at the end of July as of this date. In states like Vermont, where nonprofit employers are allowed to elect how they pay their share of unemployment taxes, either through ordinary unemployment taxes out of payroll deductions or out of self-paid funds. So in other words, nonprofit employers can hold off on paying the payroll tax for unemployment, but they end up having to pay for the full freight of unemployment benefits for people who are actually discharged and eligible for benefits. For those employers, there's an additional provision in the CARES Act that's important. First, the $600 per week is covered by the federal government. And secondly, for those self-paying entities, 50% of the regular benefit costs for COVID-19 related unemployment is paid for by the federal government. So as Ben mentioned, that's something to consider in evaluating a RIF or a reduction in force or a layoff.
All right, David, thank you very much. Looking back at our Q&A, April has been monitoring them. April, any specific questions relating to unemployment?
Yes. Is there any concern about hiring staff that has been furloughed back into a lower paying role? As a nonprofit, do we need to officially furlough hourly employees starting 6/8 and provide the NEHES notification to employees of the availability of unemployment compensation? In the normal course of business, some are consistently scheduled every week and some are scheduled as needed.
I'm not sure I totally follow that one. I might be able to follow up on that if I can see it in writing, unless one of my colleagues understood it.
I may want to break it down. I think there are two questions here.
Yeah,
the first is there any concern about hiring staff that has been furloughed back into a lower paying role?
if you bring someone back from, they may be eligible for partial unemployment. There's no concern with it legally, but the individual's benefit for unemployment would be reduced depending on how much less they're being paid in the new position.
Okay.
I would add one thing to that, that's true what David said from the unemployment standpoint, but from the pure, can you just offer to bring someone back into a lower paying job? I think there are potentially some issues that you'd have to think about in terms of discrimination if you were hiring someone else to do the job that person used to do. What's the reason that person is not being invited back? So that question maybe assumes that you're eliminating the prior position. But if not, then there could be some issues.
Okay, thanks, Beth. And then the second one is, as a nonprofit, do we need to officially furlough hourly employees starting June 8th and provide the NHES notification to employees of the availability of unemployment compensation?
I'm not sure about NEHS. If it's in Vermont, you do have an obligation now if you're terminating an employee to provide notice of the availability of unemployment compensation.
Mm-hmm. Okay, thanks, David. And here's another one for you. You've got two more. Is the $600 federal benefit taxable?
I don't know.
Yeah,
I'd have to look into that. Taxable to, it's not going to be, my sense is that it's not going to create any additional payroll tax on the employer. Whether it's taxable to the individual employee, I'm not sure.
Okay.
My understanding is that it is taxable income for the individual employee, but that it's distinguishable from the stimulus checks that some folks got, that the stimulus money that the Department of Treasury sent out, that was not taxable, but that if you're on unemployment, the additional $600 folks are receiving is considered to be taxable income for the individual employee.
Okay. All right, thank you. And then finally, we received notice of potential charges to UE benefit from the state of Vermont for an employee who has been consistently working remotely and being paid throughout this time. Of course, Vermont DOL is difficult to reach. How do you recommend correcting this with the state?
In writing and providing some documentation.
Okay.
I don't know how to alleviate the problem that the DOL's overburdened, but if the person is working remotely and being paid full wages, then they are not eligible for unemployment.
And I would like just to add to that and to reiterate what David said, in writing, make that complaint known, because I had a circumstance that came up last week that was similar, that there were benefits going to someone who was working. And it turns out that it may indeed be a situation of fraud. And I spoke with the Department of Labor's legal counsel, who said they've been having a number of incidents of fraudulent filing for unemployment benefits. So that's another reason to make sure you contact the department, even if you can't get in touch with them directly, at least document it, but by sending them a letter.
John, do we have time for one more question of David?
Yeah, and I would just reiterate, what Beth and David said is contact either through email or otherwise in writing, but what I've found with the Department of Labor is if you email them, they have been fairly responsive within 24 hours. So April, yeah, we have time for one more question.
Okay, let's see here. If you are partially reopening and you know you can't hire every part-time employee back, but you will need some, how do you proceed with notifying the employees? And do you furlough all part-timers and then call back a few as needed?
Yeah. Actually, Beth, do you want to handle that one? I think that sort of goes into the furlough layoff.
I can give it again.
Okay. Yeah, Beth.
Sure. I need to just look at that question again to make sure I'm catching all the parts of it. So you
If
would,
you're partially
so you can hire, I see the question. So you can hire some people back, but you can't hire everyone. So then that's okay. You can choose, you only have so many positions available, and you can offer those to the people that are you want to offer that to, and those that are not, then you would give them a notice of layoff if you believe that it's going to be permanent. If you think it's going to continue as a temporary furlough, then you can just let them know. I'm not, if
Yeah, and I think what the question highlights is how unique every situation is. And so I think the short answer is you really want to think through, what's going on with your existing employees, those who are on furlough, or and when you want to bring them back. The hard part is really going to know. I mean, I've talked to people that long-term planning, used to be months, if not years, and now it's a matter of weeks. And it's just really hard to determine what's going to happen. So I would go take each of those situations, do the best that you can, and explain the uncertainty to the individuals who are impacted by the decision. I think communication during these times is going to be absolutely critical. So with that, I would say thank you very much for joining our webinar. We really appreciate that you've come to us and looked to us for advice, and we enjoy putting these presentations together for you. You'll be getting a PowerPoint email from Monique along with certification information. If you have further questions, you can respond to Monique's, or you can contact any one of us. So I think with that, I will sign off, and we'll say thank you very much and have a great day, everybody.
Bye, everybody.
Thank you.
bye.